You may proceed with your closing argument.
Good afternoon. I'd like to begin by acknowledging the last 6 days you've spent paying attention to the evidence in this case. It's vital to our judicial system, and I want to thank you for that. I'm going to tell you what I'm not going to do today. I'm not going to talk about verbs. I'm not going to talk about puzzles. I'm not going to talk about rain. I'm not going to talk about plane crashes. I'm not going to talk about baseball. And I'm not going to talk about a Wheel of Fortune sign that has 2 tickets to paradise on it. I'm going to talk to you about the evidence that you've heard in this case. We're going to start here. You'll receive a jury instruction that says that you can't base your verdict on sympathy. And why do I say that? Because who here doesn't feel sympathy for Ms. Zwerner? No one. No one. We're not here to challenge that. But what this case is about, it's about real-time judgments in an elementary school on January 6, 2023. Real-time judgments, not hindsight judgments. It's about the likelihood that a 6-year-old little boy had access to a firearm, access to bullets, dropped off by his mom with a loaded firearm in his backpack, took a loaded firearm out of his backpack, aimed a loaded firearm at his teacher, pulled the trigger, and shot the teacher. It was unforeseeable, it was unthinkable, and it was unprecedented. You heard many people tell you that, but we're going to start with this person. Who was that? Amy Klinger. She's a national school safety expert. She's written a book on school safety. And she came here and she told you the framework about how decisions are made among administrators and people in school systems, and we'll get to that later. But she told you, Mr. Beniozen talked about me blaming everyone else, but she told you that everyone involved was doing an analysis that day, but they did not perceive this to be a plausible imminent threat because it was a 6-year-old. It was unthinkable and certainly unprecedented. But now we're here. We're in the hindsight phase. Criticisms to find fault. 3 years later, with the outcome known, trenches have been dug. Somebody's got to go down. We're going to blame this person for it, Dr. Ebony Parker. She was the assistant principal at Rich Neck Elementary School on January 6, 2023. We'll talk about the issues in the trial, and I'm going to move past this quickly because Your Honor is giving you jury instructions. You're going to take the jury instructions back, and you'll see all the issues in this case. And I won't belabor this issue, but I'm going to tell you something. When you get back there, I want you to look at jury instruction number 16 about assuming a duty. And you're going to find, when you read that instruction and you apply it to the evidence in this case, that Dr. Parker did not have a legal duty to protect Ms. Zwerner. She did not volunteer to protect Ms. Zwerner. You'll remember the admissions in the case that we read to you? These were Ms. Zwerner's admissions. She admitted that on January 6th, before the shooting occurred, she did not receive any communication from the defendant expressly promising or agreeing to protect her from risk of harm by JT. She admitted that before the shooting on January 6, 2023, she did not communicate to Dr. Parker that there was reason to believe that JT might possess a firearm. She admitted that on January 6, 2023, the only time she communicated directly with the defendant before the shooting was when she went to defendant's office and told her about JT's behavior during lunch. And she admitted that on January 6, 2023, before the shooting occurred, she did not receive any communication directly from Dr. Parker, the defendant, acknowledging that she knew that JT might possess a firearm. And even if you find there was an assumed duty to Ms. Zwerner by Dr. Parker, you have to find that she was grossly negligent. What's gross negligence? I love this definition. It's the absence of slight diligence or the want of even scant care. And you might ask yourself, what does that mean? It's indifference. Indifference. And the evidence in this case doesn't show indifference. Mr. Beniozen glossed over the evidence, but bear with me because we're going to walk through it. And indifference is not inadequacy. So what happened on January 6, 2023 at Rich Neck Elementary School? We'll start the day where it starts. The first person to receive communication about a potential firearm, Amy Kovac. Who is Amy Kovac? She was the reading specialist, 33 years of teaching experience, third on the chain of command in the crisis plan at Rich Neck Elementary School, worked with JT every day. So on January 6, 2023, Dr. Parker was working with Amy Kovac on winter growth assessment testing. That's state standardized testing. There's specific rules that govern it. They were working together all day. Ms. Kovac told you she saw JT coming from lunch. He was happy, and he ran up to her and gave her a hug. She told JT, make good choices and make her proud. Then the two little girls came out of Ms. Werner's room to the doorway and told her that JT had a gun in his bag. Ms. Kovac went straight into Ms. Werner's room, straight to JT, and told them what the little girls said. And she asked JT, can I have that bag? He said no. So she sat with JT for a while and asked him, do you have a gun in the bag? He said, no one's getting the bag. And she said, okay. She stayed in the classroom for 30 minutes, and made the decision to leave. She knew the child. What did she not do? Didn't follow up with the two little girls. Did not remove the backpack from the room. Did not remove JT from the room. Did not take JT down to administration. Did not evacuate the classroom. Did not call the guidance counselor, made a plan to check the backpack when they went to recess, went back to testing, and had discussions with Dr. Parker. So this is the knowledge that gets sent to Dr. Parker. Now here's the part where you've got to decide which Amy Kovac to believe. The Amy Kovac that told Dr. Parker it was a toy gun, or the Amy Kovac that told Dr. Parker it was a real gun. But her actions don't suggest she thought it was a real gun, do they? Which Amy Kovac? She testified in front of you. Her personal thought was it was a toy gun, and she had told that to HR shortly after the incident. But then she testified in front of you. She told Dr. Parker that the girls had reported to her that there was a possible gun. Which Amy Kovac to believe? Try this one. Amy Kovac's text to Dr. Parker 2 days after the incident. Look at this. Amy Kovac to Dr. Parker. You are an amazing person and educator. No one could have ever predicted this. We all did our best. We did what a true teacher will do in this situation. Be there for our children in school. As I look back, I should have sent JT out of the room with a note and a job to deliver it around the school. And I could have gotten that book bag, but I didn't. We can't look back. We can only move forward. I love you, and I'm proud to work with you. But that Amy Kovac didn't come to trial. She sat here and she threw shade at Dr. Parker. She dissed her work, and she threw shade. Not this Amy Kovac. Remember that. Credibility. You'll get an instruction on credibility, and you can use your common sense. You'll see the jury instruction. You're the judges of the facts, the credibility of the witness, and the weight of the evidence. Use your common sense in judging testimony. Think about this. Who was the second person that day to hear about whether JT might have a weapon? It was Miss Werner. She was in the classroom when this went on with Miss Kovac, 30, 40 minutes, whatever it was. She sat here and she agreed that discipline is the initial responsibility of the teacher. she had dealt with misbehavior, how she dealt with student concerns, was to first talk with the student. She told you she had taken a student by the hand, had removed a student from the classroom, and that was JT just 2 days before. He had thrown her phone, broken her screen protector, and she took him by the hand and she took him out of the classroom and brought him over to Miss West's class across the hall. She also told you that she had a classroom phone to call the officer parents, and she had requested assistance from guidance before, had requested help on the walkie-talkie. Miss West across the hall had the walkie-talkie. And the same day that JT threw her phone, she went over with JT and had Miss West get on the walkie-talkie and call Mr. Rawls to come and get them, so she knew how to remove him from the classroom. She also knew how to evacuate the classroom if she sensed danger. And remember, showed her the text. It was a year before. Miss Zwerner herself tells her friend Rosalie List, another teacher at the school, that Q was at the office all day. I had to evacuate my room early for lunch. But on this day, she was in there when Miss Kovac was there, loudly talking to JT about whether he had a gun in the backpack. She also told you in court that she had emailed Dr. Parker before. She had walked in and talked with Dr. Parker before. She had had guidance take students to Dr. Parker's office. Remember that testimony? You'd go to Dr. Parker at times. You would email her. You'd walk in her office. And if necessary, you'd get guidance to take the student to Dr. Parker's office. Ms. Zwerner told you that she had discussions with Dr. Parker about JT's behavior during lunch, but not about a report of the gun. She had discussion with Amy Kovac in her classroom about the reports from the 2 little girls in her classroom. She had discussion with Amy Kovac in her classroom after Amy spent time with JT and did not search the backpack. She witnessed JT rummaging through the backpack. She witnessed JT put something in his pocket. And she observed JT at recess with hands in his pockets and R telling JT to keep his hands in his pockets. She had discussion with Jennifer West about that, the lead teacher with the walkie-talkie, and discussion with Amy Kovac at recess. But there are things she did not do. She did not follow up with the 2 little girls. She did not speak to JT, did not remove the backpack from the room, did not remove JT from the room, did not take JT down to administration, did not evacuate the classroom, did not call the guidance counselor, did not make use of the walkie-talkie, and did not call the parents of JT. Did not seek classroom coverage to personally discuss any of this with Dr. Ebony Parker. No visit, no call, no email. You'll get a jury instruction on contributory negligence. It is the failure to act as a reasonable person would have acted for her own safety under the circumstances of this case. Any negligence of Ms. Zwerner, which was a proximate cause of the accident, will bar her from recovering. Let's talk about other people involved that day. Jennifer West. You remember Ms. West, first grade teacher across the hall? She had the walkie. Classroom right across the hall from Ms. Zwerner's classroom. Was on the playground during recess with other first grade classes. Learned about JT on the playground and the discussions about him. I was informed that he took something from his backpack. I can't speak for sure if I was told it was a weapon. That's what she said in court. She left the playground to deal with another student. Asked Ms. Zwerner to take her class back in the building. Remember, you're the judges of credibility. If you thought you were leaving a child on a playground with a gun, why would you say, why don't you shepherd your class and my class back in the building? Use your common sense. Miss West encountered Dr. Parker in the hall. And so they've come in and said Dr. Parker was indifferent. Dr. Parker was dealing with another student, Miss West's student, and she didn't say anything to her about JT. Use your common sense. There was discussion with R about what JT showed him on the playground. We've heard about that. And Miss West said, R told me, he said that JT had a gun and he saw it in the bullet. And I said, well, what color? Trying to see if it was real or not. And he said it was bullet color. In trial, Miss West had one version of that story. She was asked, Miss West, you testified that when you arrived on the playground, you weren't told specifically whether or not JT had a gun. Answer, that's what my note I wrote down notes that night, and that's what my notes say. But in her deposition, she had to admit she said something different. Your testimony under oath at the deposition preceding the trial was that Ms. Zwerner had reported to you the child did in fact have a firearm. Well, that's what I said then, yes. You're the judges of the credibility of these witnesses. John Sims, music teacher, covering phones in the office. The most important thing he told you, Ms. West didn't call him. He called her about another student, and that's when she mentioned what R had said. Now let's get to Mr. Rawls. Remember Mr. Rawls? Who was he? He was the guidance counselor. He was a member of the threat assessment team. He was part of JT's student success plan, worked with him all the time. Very familiar with JT, and he told you he had some learning and some behavioral issues. And JT had been taken to Dr. Parker's office on multiple occasions. And he, in fact, had been the one to take JT to the office 2 days prior when Ms. Zwerner asked him to. Mr. Ross told you about what happened on January 6th. He was working with Ms. West on her student that had eloped, that Dr. Parker was all involved in. So Dr. Parker, I think it's been said that she was sitting in there in her armchair. She wasn't sitting in her office on her armchair. She was working. She was dealing with other student needs. Ask yourself, does it make any sense that she would attend to that and blow off a gun in the school? Mr. Rawls said, I stumbled on some information about JT. No one called me. He's coming down the hall dealing with Miss West's student, and she tells him that R said something about ammunition or bullets. So Mr. Rawls spoke with R, and he did not interpret it to be a threat. It was a 6-year-old. 6-year-olds say things. Mr. Rawls, ever heard anything about a gun? No. You heard something about bullets? Yes. So at the time you did not feel the need to remove JT from Ms. Zwerner's classroom? No, I did not. Later that day, or a little while later, Mr. Rawls had a discussion with Dr. Parker about the other student and about ammunition or bullets, and the bag already had been checked. He learned that the book bag had been checked. And he discussed with Dr. Parker, checking the person. Dr. Parker looked at the clock and said, why don't we wait for his mother to arrive? And he said he understood because he was 6. And so think of the context that was going on at this point. He had been allowed, Ms. Kovac had investigated. She felt comfortable leaving the room. She felt comfortable not taking the backpack. She was not a young teacher. She was very experienced. She worked with this child every day. She knew this child, and she felt comfortable leaving that room. So that's a context. And then Ms. Zwerner didn't remove him from the room. And Mr. Ross told you he understood because it was a 6-year-old. And he didn't feel the need to go around Dr. Parker. He didn't feel the need to do that. It's a 6-year-old. Later in the day, Mr. Ross had gone back to his office. There was a lockdown, and he was coming down the hall. And he ran into some custodians. He didn't know there had been a shooting. And one of them said, they got him, and he said, got who? He told you he didn't have any idea who they were talking about. It was like, oh, it's JT. I knew it. I knew it. He didn't say that. He had no idea. And Mr. Ross told you that he went to his office and cried. You'll see that in the statement that HR had Dr. Parker write after, a couple days after. People hadn't lawyered up at that point. Maybe some of her language wasn't the best, but she told the story. She told that she cried too. They told the truth. No one saw this coming. Now let's talk about the experts in the case. Largely, their expert agrees with Dr. Klinger. Let's talk about it. And Shufflebarger. But let's first say, who is she? She's retired from the Virginia Beach Public Schools. She's never been an expert before. She was introduced to the case through her sister-in-law, one of Ms. Werner's attorneys. She agreed that this was a rare event. She agreed that the assistant principal is not solely responsible for school safety, that it's a team approach. You remember the Q&A? You agree that it's unfair to judge someone's conduct with 20/20 hindsight vision. I can see that. And you agree that Dr. Parker, in evaluating information regarding a 6-year-old having a loaded gun at school, something that had never happened to her, she didn't know the outcome of the day. Correct. She also agreed that school safety is a team approach. It's not just one person's job, and we'll get to that in a minute, because Dr. Klinger made that clear to you and how that would be a terrible idea for it to be just one person's job. She agreed that the teacher in the classroom is the first line responder about student behavior. She agreed that assistant principals must rely on other staff members and teachers in determining whether reports are credible. She agreed that searching a student is a judgment call based on a lot of factors. She also agreed that it's preferred that parents are present during body searches of little students. She also agreed Dr. Parker didn't refuse to search JT. She wanted to wait until his mother got there because the level of concern was not high. Mr. Rawls had said it wasn't a credible threat. He told you that. She agreed that age is a factor in determining whether to body search a 6-year-old. Age and a lot of other things are a factor, she told you. Sex of a student's a factor. She agreed that you want to handle the student with dignity and that there are legal rights to their privacy concerns in body searching children. Most importantly, she told you she worked 40 years in the Virginia Beach public school system. And she told you that that never happened. No child, no elementary child ever brought a gun to school. Dr. Shufflebarger also agreed with me that Ms. Kovac and Ms. Zwerner were the first line responders to the reports about JT. She agreed that Ms. Kovac and Ms. Zwerner were in the classroom with JT after becoming aware of a potential weapon. She agreed that Ms. Kovac and Ms. Zwerner did not confiscate JT's backpack and that they did not remove JT from the classroom, and that Mr. Rawls had not determined there to be a credible threat when he spoke to Dr. Parker about JT. She agreed that other individuals did not stop what they were doing. She said she should have stopped what she was doing, Dr. Parker, but she agreed that no one else did. And as you recall, she didn't know the facts of the case. She told you that it was 2 teachers that came and talked to Dr. Parker about body searching JT. And on cross, I had to get out the truth that it wasn't actually 2 teachers. She then acknowledged it. It was actually the guidance counselor on the threat assessment team who worked with the child every day. Surely, if he thought at that point there was a credible threat to search this child, he would have done something. You saw Mr. Ross. Anybody doubt for a minute that he wouldn't take action if he felt like he needed to? Now let's move to the defense expert. You saw Amy Klinger the defense expert. She has a Doctor of Education from the University of Toledo. She's a career educator and administrator. And now she works with school safety as a trainer and as a consultant. She founded the nonprofit called the Educator School Safety Network. She's a full tenured professor of educational administration. She's an instructor for FEMA and Homeland Security coursework. She has boots on the ground experience. She was a school principal from 1995 to 2008. She's researched, she's published, she's created training courses, and she's been an expert witness 25 times. Most of the time, she's against the school administrator. But she came here and she wasn't against the school administrator. She wasn't against Dr. Parker. She told you that Dr. Parker did not breach professional standards with respect to Ms. Zwerner on January 6, 2023. And she told you that Dr. Parker, it was her opinion that Dr. Parker was not indifferent to Ms. Zwerner on January 6, 2023. She detailed how she came up with that opinion. She reviewed body-worn camera footage from the Sheriff's Department, including an interview with Ms. Kovac right after the incident. She reviewed the school board video interviews with people that were involved in the incident. She reviewed forensic interviews, witness statements, incident reports. She reviewed the protocols, and you're going to get an instruction about protocols. Protocols, you'll see, does not set the standard of care. But she reviewed them, and she told you that Dr. Parker didn't violate any protocols. She reviewed all the depositions taken in the case, and she reviewed JT's school records and his court records involving his mother. She reviewed all of that before she was willing to come and sit on the witness stand, swear to tell the truth, and give you her opinions in this case. Dr. Klinger told you that school safety is everyone's responsibility. It's a collaborative endeavor. School safety concerns do not occur in a vacuum. Every person in a school organization has roles and responsibilities related to school safety, every single person. A school administrator cannot establish the credibility of a potential threat alone. They cannot be everywhere, and they cannot see everything. She told you that it's important that the school administrator get information and disclosures from the people who are closest to the event. Dr. Klinger told you that discipline is the initial responsibility of the teacher. That's a standard nationwide. It's also in the Rich Neck Elementary School Staff Handbook that you've seen, and I think it will go back to you, back to the jury room with you. Important to Dr. Klinger was the context of what else was going on and what Dr. Parker knew. That JT had been allowed to remain in the classroom and class instruction went on. The school day went on. The students went to recess. The first grade teacher discussed suspicious behavior on the playground, but they did not remove JT from the playground. Ms. Zwerner did not make any reports directly to Dr. Parker about a report that JT had a weapon. And she explained why that matters. She talked about first-line responders. We've mentioned it before, I want to mention again. And what she said is when an administrator is evaluating a threat, it's important to know what sort of actions are being taken so that what are the first-line people doing regarding the credibility and the appropriate action to take for a response. And what she told you is that what really matters is plausibility and foreseeability. And she said when you're discussing a 6-year-old, it's much different conversation than if you're discussing a middle school or a high school student. This is a 6-year-old. And she told you that when discussing a 6-year-old having access and ability to bring a weapon to school, clearly, we know at this point, it's unprecedented. That means it hadn't happened before. It was largely unthinkable and certainly unprecedented. Your job is to consider only what Dr. Parker knew at the time. And Dr. Klinger wasn't the only one that told you it was unforeseeable and unprecedented. Dr. Schuffelbarger. She agreed that in evaluating information regarding a 6-year-old having a loaded gun on January 6, 2023, it was something that had never happened, and that Dr. Parker would not have known the outcome of the day. Ms. Zwerner herself told you that when she saw the gun for the first time that day, when it was unfortunately pointed at her, that she was shocked because she didn't expect to see a real gun. And she had been in the classroom with this child and on the playground with this child. Amy Kovacs said it too. Who would believe that a 6-year-old would bring a gun to school premeditated to shoot his teacher? Mr. Rawls said it. He talked about hindsight bias and feeling regret about what happened. But let's look at what Corporal Blythe said. He was one of the first responders, the sheriff. What did he say? We were quite taken aback. We didn't expect to see such a young suspect. It was unforeseeable, it was unthinkable, and it was unprecedented. I submit to you that Dr. Parker did not assume a duty of care to Ms. Zwerner. She did not breach a duty of care, and that she was not grossly negligent. And it stops there. And you don't even get to damages. However, I need to talk to you a little bit about damages, and I'm going to tell you why. As you may recall, I questioned some of Ms. Zwerner's witnesses about her damages. And there was a reason I did that. Ms. Zwerner has come to this court asking for $40 million from Dr. Parker. And she told you that she cannot even open a bag of potato chips. And her counsel, he repeated that today. As an officer of the court, and as my ethical duty to Dr. Parker, it's my job, unpleasant as it is, to come in and tell you there's a different side to that story. I'm an officer of the court. And so I questioned Ms. Zwerner and some of her witnesses about the fact that she has gone to cosmetology school, passed with flying colors, and is a licensed cosmetologist. And some of her witnesses have come in and said she only wanted to be a teacher, but I've shown you, have admitted into evidence, are the texts that shows there's another side to that story too. And the other side to that story is that it was something, teaching was hard. And I'm not saying that to cast any blame on Ms. Zwerner, but to say she had thought about going to cosmetology school for years. So to come into the court and say, I only wanted to be a teacher, that's all I ever wanted, and now I can't, even though I don't think anyone testified she couldn't, I need $40 million. It's my job to tell you there's another side to that story. Ms. Zwerner and some of her family members have said that she can't leave her house, she's become reclusive, that she's withdrawn from the community. And again, I have to show you, when someone's asking $40 million from Dr. Parker, I have no choice but to say there's
Objection, Your Honor. The statement from Dr. Parker is an inappropriate statement of law.
Say that again?
The statement from Dr. Parker, I think, is contrary to the jury instruction.
I don't
They were
think-
I
there
didn't
to
make-
assess the damage.
I don't think she said anything that Dr. Parker said.
No, I
I
did not.
didn't hear that.
Stated from Dr. Parker, was counsel's argument.
All right, you overruled. You may proceed.
I showed you the social media posts that Ms. Werner produced in discovery. She produced them to us. Flip through them. She's reaching out to international celebrities to go to the concert 9 months after the shooting. Again, officer of the court, duty to my client, I have to tell you the other side. It's my job. And that's why we brought you Dr. Hagan. Dr. Hagan explained to you what a forensic evaluator does when determining whether someone has PTSD. Dr. Watson came, as eloquent as he was not Ms. Werner's treating healthcare provider. He was a retained expert paid for by the plaintiff to talk about her damages. But he did not look at her treatment records from before the shooting. He did not see that there had been diagnosis of PTSD before. And Ms. Werner herself, the last question exchange we had, she had to admit that she had not been truthful with Dr. Watson. I'm not minimizing what happened to Ms. Werner. I'm not doing that. I'm doing my job. I have to bring the truth and the whole story. It's the brutal honesty that Mr. Beniozen stood up when we selected this jury and told you he wanted. I have to do it. This case has been a long road for a lot of people. Mr. Beniozen glossed over the evidence in the case, and I want to thank you for listening to me as I went point by point what happened at Rich Nut Elementary School on January 6th. I went through the evidence, you heard the testimony, you weigh the credibility, these are the facts. And I would submit to you that when you go back and you consider the facts and the jury instructions that the court gave you, I would ask that you find that Dr. Parker did not assume a duty to Ms. Werner. She did not breach a duty to Ms. Werner, and she most certainly was not grossly negligent or indifferent to Ms. Werner. What happened at Rich Neck Elementary School on January 6, 2023 was a terrible tragedy on so many levels. So many levels. There's no one that does not think, that thinks otherwise. It was a tragedy that until that day was unprecedented, it was unthinkable, and it was unforeseeable. And I ask that you please not compound that tragedy by blaming Dr. Parker for it. Thank you.
Thank you.